Today on Off the Clock, we are going to be chatting about employees recording conversations in the workplace. This seems to be something that's happening more and more. We're going to talk about whether it's legal, whether employers can prohibit it, and whether there's any circumstances in which we might want to allow it. Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. As you know, we often have what you call themes, questions that repeatedly come up from a number of different clients across different industries, and this was one for me. So I thought it would be fun for you and I to chat about it.
Well, I have not had a rash of calls about this recently. This is one that comes up about once a month, I would say.
Yeah.
Year in, year out. Much more so, I would say, in the past, 5, 8, 10 years.
Right.
And obviously because a lot of people have phones that have recording features.
Have phones, and also a lot more meetings are done virtually via Teams and Zoom and platforms like that, in which there is just a recording option. And so sometimes I've had phone calls from clients saying they were halfway through a Teams meeting and they realized that the meeting had been recorded by the individual.
To carry that even further, I had a matter where it wasn't the Teams platform doing the recording, but the employee had their phone taking a voice memo on their desk because everyone was remote.
Right.
There was no way to know.
No way to know.
It's just...
That's right.
It's probably coming up more often just because it's so easy.
It's
just so easy.
That's right. We're far away from the times when it was somebody hiding a tape recorder, right? An actual tape recorder in which they push down the recording button and we're trying to hide it in their pocket or their purse.
The very first time this came up for me as a lawyer, a woman had a feeling she was going to be called in for a termination meeting that day.
Right.
In fact, she was right, but she didn't know exactly when it would happen. So she had a small tape recorder, like a dictaphone size, in her purse all day, recording all day, because she didn't want to fumble with it when HR or her supervisor came to say, "We want to meet with you." So this included trips to the bathroom. And it was my job as a new associate lawyer to listen to the recording and see if there was anything relevant to the litigation. And that's when the first time I questioned my career choice.
That's when you knew you were in the right place.
And so, while recordings are much more common now because of cell phones, let me say, as a person who has to listen to them, I appreciate that we can be more surgical in what we record.
Oh my gosh.
And what we don't. That is a true story.
Awesome.
Yes, I will not mention the client.
So when I get usually the first question I'm asked, right? And by the way, I often get these phone calls after the fact. We find out, of course, right? We didn't know an employee was secretly recording a conversation. The first question I get asked is, are they allowed to do that under the law? Right? Isn't that illegal? And that comes from a place of feeling a little violated,
exposed.
Maybe.
I was going to use the word exposed.
Right.
Yeah.
I didn't know you were recording the conversation. And so let's start there.
Yeah. Yes, because often our clients don't like our answer. So let's just get it out.
Right.
Under federal law and Michigan law, we are what it's called single consent, meaning only one person in the conversation has to know and approve of the recording. This means we can't eavesdrop. Right, you can't install, or an employee can't install a listening device in a conference room or something like that, right? Where no one in the room is aware that there's a recording happening. But in a typical meeting where the employee is present, there is nothing under federal law or in Michigan that prohibits that employee from recording without telling you about it.
That's exactly right. As long as one party to the conversation knows it's being recorded, it's not illegal to do that. There are some states that are two-party consent states.
Many, yes.
Or all-party consent states, right? And they would say everyone on the conversation or both parties to the conversation has to know, has to be aware and consent to the recording. I know just offhand, Florida is one of those states. I don't know offhand all of them.
Yeah, it's pretty well split. So when you call Sarah, me, or anyone else to ask the question, we're going to ask you, right? Where the recording took place. And
Yes.
I will say this, it gets very complicated when people are all over the place and the recording is of a virtual
Oh my
meeting.
goodness.
I've had to look into
What a
that
fun
recently.
question.
It's too much for this conversation, but it can get
Very
complicated. For me, that's fun. Not so much for the clients, but it's not so. It's not always so easy to determine whether it's lawful or not.
So then, assuming this happened in Michigan, right? The first answer I get, you're right. Clients often don't like it. Right. So then the next question I get asked is, well, can we tell them they're not allowed to do that? In other words, you can't record a conversation in the workplace unless everyone is aware that it's being recorded and it has consented to the recording.
Yep. And the answer is
a little more palatable. Still not maybe exactly what they want to hear. The answer is generally yes. Okay.
We can have a policy.
And a private employer can.
Yeah.
We get into other concerns if it's a public employer and there's constitutional concerns and things like that. So let's just assume this is a private employer. You can, but, and this is a big but, there is an NLRB decision. Yes.
Whenever you say NLRB.
You know where I'm going with this, right? You know where I'm going with this.
They spoil everything, don't they? Yes. Okay.
Involving Whole Foods, actually. And that decision held that a broad policy that prohibits any sort of recording without all parties consenting to it can interfere with employees' Section 7 rights, i.e. their right to engage in protected and concerted activity. And in that case, Whole Foods had implemented a policy. It was in its general information guide, and it essentially prohibited employees from both taking pictures and recording conversations unless prior approval from Whole Foods was obtained and all parties to the conversation gave their consent. Wonderful policy, I would say, right?
Sounds good.
And it got challenged on the basis that employees should be able to take pictures and record conversations that involve protected and concerted activity. And the NLRB agreed that the policy as written was overbroad and violated the National Labor Relations Act.
So what are employers to do?
Yes, exactly.
What are employers to do?
The first thing I'll say is this. Just let's level set for a minute. Almost, and maybe even all, of my conversations with clients about a concern regarding an employee having recorded a conversation did not involve a conversation that in any way touched on protected and concerted activity.
That's been my experience as well. Right. It's almost always a termination.
It's a meeting
or a discipline meeting.
That's exactly right.
Yeah,
it's a meeting
always.
about something involving only that individual employee, and they're worried they, as an individual, are going to be in trouble or fired, and therefore they record the conversation. Does that make sense?
Yes, almost always.
And just for the purpose of our listeners, the term protected and concerted means, the second half of that concerted means that activity has to be not only regarding that employee, but also on behalf of other employees. Okay, so for example, if an employee were at a staff meeting, and wanted to stand up and assert their right and the rights of others to have higher wages, okay? A belief that they were underpaid as part of a meeting and wanted to record themselves doing that, the NLRB would say, we can't stop them from recording that. They have a right to do that.
Okay.
Same with like picketing activity, strike activity, etc.
Got it. Okay.
So with that level set, I think that there is certainly plenty of opportunity to have a policy that accomplishes what we're really worried about and has a disclaimer in it. It doesn't have to be long, doesn't have to be overly complicated, but a disclaimer making clear that what we are asking them not to do or prohibiting them from doing does not include that type of protected and concerted activity.
So we shouldn't get too wrapped up in that Whole Foods
No.
decision and let that stop what's really important to us.
Correct.
And what happens 99% of the time.
But if you're going to adopt a policy, I would have it legally reviewed.
Yes, agree. To make sure,
Is what that all means. To make
stepping
sure
in it.
you're not stepping in it under Whole Foods.
And then, of
That's
course, when
exactly
you're
right.
actually making decisions about
Yes.
if an employee says, I'm going to be recording this, before you say,
Yeah.
no, you're not.
Or you want to,
You
or
need
you
to
want
be
to,
aware of that.
or you want to
Yeah.
discipline an employee or fire an employee for violating the policy.
Right.
And what they did involve protected and concerted activity. That's when you really want to take a time out and call your favorite employment attorney.
Yes. Agree.
And let them help guide you through it.
Let's pivot to an equally common client question I get. The first is, as you already mentioned, I just found out I was recorded.
Yep.
Are they allowed to do that? What do I do, et cetera? But in my life, just as common is the question, should I allow them
Yes.
to record it? They have asked if it's okay
Yeah.
if they record the meeting. And what do you think? Or should I record the
Yeah.
meeting because they are
Right.
concerned that an employee has misconstrued there's the HR person's statements, right? So should we say yes upon request or should we initiate
Yeah,
ourselves? And that
right.
opens up a whole new conversation. And whether you should have the policy you just
Yeah.
mentioned.
Or whether
too.
you might want to write the policy in a different way.
Right.
And I know you and I have chatted about this a little bit, and I think we might have kind of a unique view on this, or maybe a view that might surprise some of our clients,
Yeah.
because we're litigators.
Right.
I'll just
And that
start.
means we want
Yes.
to know
Yeah,
what was said.
that's exactly right. The times in litigation in which I'll say, been fortunate enough
Yeah.
to have a recording of a meeting that is important to the case, it has only been helpful
I agree.
across the board.
Yes.
And so I am pretty open-minded to the idea that there could be there are times in which it makes a lot of sense and can be to the benefit of the employer actually to transparently record a conversation in a way that so that a clear record is made of what exactly was said.
Right.
And that also protects their interest. Now, I will say this. One of the primary legitimate concerns about having these recordings is what? Lack of control over what happens to the recording, right?
Social media, et cetera.
Yes,
Yeah.
an employee can take a sound bite from a
Yes.
meeting,
Right.
a snippet.
Yeah.
You know how our news is these days, right?
I have no idea.
Can take a sound bite, a snippet, and put it out into the world.
Yeah. Yeah.
And that's really scary.
Yes, it is.
And so I'm not implying that we would just allow a recording without any sort of guardrails in place or protections about what happens to the recording and how that works. But for example, I'm very open-minded to the idea of if an employee asked to record a conversation, rather than reacting and say, absolutely not, we don't allow recording in the workplace, maybe the answer is, you know what, let's agree. Yeah, sure, let's do it. But let's both have the same, there's one recording device, right, in the middle of the table. We're not going to both be taking competing recordings. And we're going to agree then that the recording is going to be transcribed by, could be a third party. I've done it actually, and we send it to a court reporter or somebody like
Sure.
that who's not very expensive, and they transcribe the recording.
Yeah.
And then both of us get a copy of that written transcription.
Right.
We're not going to give you an electronic copy of the recording,
Right.
but we give you a copy of the transcription. And if you think that something was left off or there's been a mistake that's been made, we'll be happy to talk to you about that and address it.
Great idea.
That has worked really well in thorny circumstances where an employee feels very strongly about recording a conversation. And I think could be helpful down the road as well.
I think sometimes employees ask to record these are the ones who ask, remember, ahead of time, to put the supervisor or the HR person back on their heels a little bit, right? To make them a little nervous, right? And so we shouldn't be, if we're doing what we should be doing, right? And decisions are well-founded in all of the things, we shouldn't react in a defensive, nervous way. Your reaction is much more likely not only to lead to control of the recording and establish what was actually said or not, but also communicate to the employee, we've got no insecurity about what's about to
the
happen.
Conversation we're going to have.
Yeah. Yes.
Right.
Exactly.
And in fact,
the world can hear. We don't mind because we know this is an appropriate conversation to have.
I've actually had employees request to record conversations, interestingly, not just because they think they're in trouble, but because for a variety of reasons they're concerned about understanding and retaining everything they're told at the meeting.
As an accommodation, is this going to spill over into the ADA accommodation world? But I have had that too, yes. For people that have trouble retaining verbal instructions or information, they may have it recorded and then re-listen to it or have it transcribed because visually they retain much more than they do verbally.
And the traditional way of doing it would be to say, that's fine, we'll send you a summary of what we said after the meeting, which is also okay. But this could also be a different way of accommodating that need for some sort of written record of what was said at the meeting.
Yeah,
and giving that to them.
We've had cases with hearing impaired employees, right, who can't, especially on Teams or Zoom meetings, have more trouble hearing than they do in person. And so related to the recording, we've had requests for subtitles too. And both of those technologies, I believe, this is just a little add-on to the topic today, but both of those technologies do allow for subtitles. So that goes to just because someone requests a certain accommodation, if there's another accommodation that could work, you can consider that.
Yeah.
So instead of recording and having meetings transcribed, et cetera, we could say, would having subtitles in our meetings be helpful to you? Would that solve the problem? And sometimes it does. Right? So technology can be our friend.
That's exactly right.
Yeah.
Technology can be our friend. That's right. So I guess key takeaways today for me are don't assume it's illegal for somebody to record a conversation if they're a party to the conversation. It often is not. It's often perfectly legal. In fact, it is in Michigan.
Yeah.
But it is also possible to adopt a policy with guardrails in place. And when you adopt that policy, think about whether there might be circumstances in which we do want to leave the door open for a meeting or a conversation to be recorded with the consent of all parties and have a path in place to accomplish that.
And when an employee asks to record a meeting, consider saying yes.
Yes.
With certain guardrails in place.
Yes.
But yeah, consider saying yes.
That's exactly right.
Well, this was great.
Awesome. Thanks, Rebecca.
Thank you, Sarah.